The last panel of the morning is on the Fourth Amendment and the future of privacy. Obviously something of which we've discussed a little bit this morning in some tangential areas, but something of which I think we're all very interested, something that is changing right before our eyes, and we have an awful long ways still to go. I don't think it's any surprise that out of all the panels we've had this morning, that CWAG selected me to moderate one where there's nothing to moderate. And I'm somewhat appreciative of that. And I will also spare you, for two reasons, I will spare you my wisdom on the subject matter and leave it up to our guest speaker. For two reasons. First of all, shortage of time. Second of all, we have a guest speaker today who I think we're very, very privileged to have here. We've been very fortunate that he has joined us in the past. I think he's spoken to most of us as AGs individually about various subject matters and shared his knowledge and insights with us. He has cooperated with our offices, certainly has presented at various AG-related meetings in the past as well. I would note that I think CWAG did intend to have a panel, but Edward Snowden couldn't make it and declined our invitation. But, you know, it's very interesting. I think that in this circumstance, it's one of those rare circumstances that we actually, I don't think, need a panel. We have a very learned, a very experienced, very educated, and I think very objective speaker before us today. And I think you need to look no further than the front page of the business section of today's New York Times to know that. And the New York Times and other, of course, I think media, you know, I think I would surprise you all because all of us AGs would dream about an article like this, wrote a very good article about Brad Smith today that was very favorable and complimentary and balanced, and I think we all dream of having an article like that someday, so congratulations. I encourage you to read it. It certainly touches upon what he's talking about today and is very timely. Brad, as you know, is Microsoft's General Counsel and Executive Vice President. I won't read his entire resume, but I'm going to read part of it because I think it's just absolutely amazing that I can say all of these things about any one individual, certainly one in his capacity. He's responsible for the company's legal work, its intellectual property portfolio, patent licensing business, government affairs, public policy, corporate citizenship, philanthropic work. He's their corporate secretary and chief compliance officer. There's a man who wears many hats, many significant hats, and on this issue of the Fourth Amendment and privacy, he has been integrally involved not only in our country, but across the world. And I think he probably has some very timely information to share with us. So without further ado, Brad Smith.
Thank you. Well, as somebody who spent my first 18 years of life growing up in Wisconsin, it's an honor to be introduced by the Attorney General for the state of Wisconsin. And as somebody who has spent 18 years living in the state of Washington, I can't help but notice the attire today of the Attorney General for the state of Washington. It's a real pleasure to be here because I think I am certainly one individual who appreciates just how important this group is when it comes to the topic of privacy. It was 9 years ago, last month, at the summer NAG meeting in Montana that this group first addressed the privacy issue. And I don't believe there is any group of officials in this country who has been as focused and as steadfast in moving this issue forward. Nor has there been anyone who I believe can match Julie Brill for having taken the learning that has been developed at the state level and going to Washington and building bridges between Washington and the state capitals. A lot has been accomplished in the last decade, but all of that, I think in many respects, has to be compared to what has indeed been a momentous last year. It is a year that has reshaped the privacy landscape, certainly here in the United States, and to some degree, quite literally around the world. It is a year that, of course, was sparked by the field trip, if you will, that this gentleman, Edward Snowden, took when he took his 4 laptops and got on a plane and first went to Hong Kong and then went on to Russia. But the issues that he has raised has set in motion a discussion that I would argue was inevitable. It was inevitable because whenever there is a moment of national crisis, as there was after 9/11, the pendulum swings in one direction, and yet inevitably the pendulum always swings back. We've seen this time and time again in our nation's history. We saw it during the Napoleonic Wars under John Adams. We saw it in the Civil War under President Lincoln. We saw it in World War II, when Franklin Roosevelt interned Japanese Americans solely because they were Japanese American. So it was inevitable that the discussion that we're having today here and across the country would take place. And I think what really matters is the principles that we all need to think about as we engage in this discussion. Principles that are important for the relationship between citizens and the government, principles that are also important for the relationship between consumers and companies. And what is unique in this room is that we have elected officials who are given the mandate to think about both of those pieces. I can't help but think about these issues without going back to the principles that were given birth in this building, Independence Hall, in 1776. And yet what I think is interesting for this topic is not what happened on July the 2nd of that year when the colonies voted to become independent, not what happened on the 4th of July when the founders signed the Declaration of Independence, but what happened on the day in between, July 3rd, 1776. On that moment, on that morning, John Adams got up, and before he walked over to Independence Hall, he did what he often did that summer in Philadelphia. He wrote a letter to his wife, Abigail, back in Boston. And as he wrote that letter, reflecting on what had happened the day before, thinking about what would happen on the day that would follow, he put it into perspective by recalling what for him throughout his life would be the defining moment that had started it all. It was a moment that occurred in this building, the State House in Boston. It was a moment that had occurred in 1761, a moment depicted in this painting when a lawyer, James Otis, stood up and challenged what the British government had issued, what was called a general warrant or a writ of assistance. It was a warrant that had empowered the British officers without any probable cause to go from house to house to house to house in search of customs violations. Otis argued that this was a fundamental violation of the rights of a free people. And interestingly, he lost that case. But as he argued it, in the audience sat a 25-year-old young man studying for the bar, John Adams. And Adams, throughout his life, would say that it was that day, that case, that courtroom, and this issue that set this country on a course for independence. That was 253 years ago. As we may hear, we grapple with these same issues again. And as we do, I think one of the most important things we need to do is acknowledge that this is not an issue of one side being all right and one side being all wrong, but rather it is an exercise in balancing important goals that we must think about together. It certainly starts with the protection of the public's safety. This is something that we at Microsoft have the opportunity to work on every day, including with many of you through our digital crimes unit. We see the dangerous world in which we live. We see the threats of technology and how technology is sometimes exploited at the expense of children or older people or just consumers across the country. But even as we grapple with these new threats, it is equally important that certain fundamental values continue to endure. And these are, of course, more than anything else, the values and principles that are enshrined in the First Amendment and its commitment of free expression, the Fifth Amendment and its assurance of due process for all of our people, and the Fourth Amendment, and the guarantee it provides so that all people will be secure in their persons, houses, papers, and effects from unreasonable search and seizure. Our challenge is to balance not only public safety with these fundamental freedoms, but to do so in a way that takes stock of changing technology. This is, of course, something that those of us in the tech sector have had the opportunity to experience firsthand for many years, in some cases, many decades. It was, in the 1970s, the industry that took a computer that was bigger than this room and instead turned it into a device that could be literally in everyone's home, and now in everyone's pocket and purse in the form of a cell phone. And yet, interestingly, in the 1980s, when Americans moved their most sensitive information from their desk drawer to their desktop, they did so without having to worry about security and privacy. The computers of those days were not even connected to anything that had yet been named the internet. And yet, as the internet emerged, and as we see today, as people move their data from the desktop to the cloud in a data center, one thing remains of paramount importance. It is something we see each and every day. People will only use technology that they can trust. And it is this fundamental trust, the ability to trust in technology and have confidence in the protection of personal information, that is at stake once again. We at Microsoft have grappled with this issue for a dozen years. I became general counsel of the company in July of 2002. And of course, many of the issues we've worked on over the years have been non-public. They've been subject to security classification. And it was therefore with special interest that we paid attention to this story that ran in The Guardian last summer, because it detailed what to then had been a private, non-public program that the NSA had been running since 2002, asking companies voluntarily to turn over large amounts of consumer email so that they would have it in a database. It was interesting because this story actually talked about an Inspector General report from the NSA. And the Inspector General's report talked about a number of companies, not by name but by letter, companies A through H. We paid special attention to the description of company F, because the IG's report that was published said that in October of 2002, the NSA had approached the personnel of companies F's Department of Legal and Corporate Affairs. I can tell you that there are a number of tech companies today that have a department called Legal and Corporate Affairs, but I can also tell you that to the best of my knowledge, there was only one company in 2002 that had a department by that name. It was Microsoft. And the report detailed that the NSA had asked Company F to turn over consumer email, and that Company F said no. And I can tell you today that it was one of those meetings, as one sometimes has, that one always remembers. I remember talking with our CEO, Steve Ballmer, in the fall of 2002, and we talked about John Adams and Abraham Lincoln and Franklin Roosevelt, and the fact that the decisions we made would need to stand the test of time. And in our view then, and in my view today, the only principle that makes sense to apply if you work for a tech company is to turn over the information of consumers and other customers only pursuant to legal process and the rule of law. And if there is a government that doesn't feel that the law goes far enough to reach everything that it desires, then it should come not to us and ask us to go beyond the law. It should go to the people's elected representatives and ask them to give it more legal authority. That was a principle that made sense in 2002. Thank goodness, I say we adopted it. It is a principle that I believe needs to continue to guide us today. It was for that reason that we took the step, not lightly, to file suit against the United States government last July, asserting that we had a First Amendment right to share with the public more information about what we were providing to the United States government pursuant to legal process. And it was good news when the Justice Department settled that case with us and others in February, following President Obama's speech on the 17th of January. But important issues remain, and more needs to be done. The Congress is continuing to debate whether to end the bulk collection of consumer information that today is obtained without probable cause, with respect to the individuals whose records are being obtained. And there are other important issues as well. Fundamental questions about how our courts should work with these sensitive issues. Because despite our long-standing jurisprudential history, there is a court, the FISA Court for Foreign Intelligence Surveillance, that today operates without an adversary process, without an opportunity to hear any competing views, and that makes decisions that mostly remain unpublished and therefore out of the view of the American people. And in addition, there are other questions as well, because as data has moved to data centers and around the world in the cloud, governments are asking, how will they obtain what they want? Last week was actually a significant week, because on Thursday, the British government passed a new law that gives the British government the legal authority over any company that does business in Britain and obligates it to turn over data, including emails of customers, regardless of where in the world that data is located. If there is an American citizen who has data that sits in a data center in Iowa or Wyoming or Oregon or California or Washington or anywhere else in this country for the first time since 1776, the collection of that data is now the subject of British law. And yet this is not just an issue for the United Kingdom, it is an issue for the United States as well. Because the US government too is thinking about where it wants to collect data. And we recently received as a company a warrant that was granted by a magistrate seeking data that we found did not reside in the United States. It instead resided on this island, Ireland. It was down the street from this corner in this village outside of Dublin. It's in this building, a Microsoft data center. And for that reason, we filed suit to contest that warrant. Because indeed, since our Constitution was adopted, it has been accepted that warrants go to the water's edge. No government has the authority to penetrate the sovereignty of another without that government's and that country's consent. And yet this, after all, is worth keeping in mind. We're not talking about Iran, we're talking about Ireland. We're talking about an ally. We're talking about a friend of the United States. We're talking about a country that is itself a democracy and has laws in place to protect the privacy of its citizens. Clearly, rather than rush forward into a world where each government is seeking to reach into the data centers across borders and in other countries, it makes more sense to figure out how we can construct a framework that will ensure due process and the protection of people's rights, and yet also ensure that law enforcement can go forward so that governments can work together. I believe that is an achievable goal, but it is a goal that will be achieved only if governments set their minds to it. And our government, above all, a government that has set the foundation for what it means to protect the privacy of people, to protect the fundamental rights of citizens, needs to lead the way. Ultimately, I would say that we need to step back. I believe we need to step back as an industry and recognize that as important as the surveillance issues are of the last year, we can't act as if they are the only privacy issues that matter. In fact, if you look at what has been happening at the state level in the United States or at the European level in Europe, it is people like you who've been at the vanguard for the last decade of thinking through how privacy matters for the relationship between consumers and companies. I think we need to recognize that we have two issues that in effect are two halves of a common whole. Because whether you're talking about the relationship between governments and citizens or the relationship between companies and consumers, one thing is clear. There is a common word that should be applied to citizens and consumers. They're called people. And what we're fundamentally talking about is the rights of people in a digital era in the 21st century. There are some who say, including in our industry, that privacy no longer matters, people don't care about it, get over it, it's dead, move on. I disagree. I've always disagreed. I've disagreed when I had the opportunity to attend that meeting in Montana in 2005. I think it's worth reflecting on the fact that when we're talking about privacy, we're talking about a value that has been actually alive and well since the 1890s. It's when Louis Brandeis wrote his now famous article in the Harvard Law Review, well before he joined the Supreme Court. And he talked about the way people put it in his day, the right to be let alone. But what has always been interesting to me about that article is that it started not by talking about privacy, but by talking about technology. He talked about how the camera and other mechanical devices had changed the privacy equation for the people of that time, and how the law needed to adapt to take account of this new technological era. Of course, today one frequently finds people and they say, well, that was then, this is now, people cared then, they don't now. Look at Facebook, they say. Look at the wild success of Facebook. Clearly, people must not care about privacy. I happen to remember the day in 2007 when we at Microsoft made an investment in Facebook. The most interesting thing from a technology perspective was that day, that year, 2007, Facebook had 25 million users. MySpace, a competing social media site, had over 100 million. Do you know how many times in our industry one company reaches 100 million users with a 4-to-1 lead and then falls rapidly behind? Almost never. And yet this is what happened in the 5 years that followed. How did Facebook happen to grow, and how did MySpace happen to stagnate? Well, David Kirkpatrick, a well-known technology writer who wrote what is still to this day the defining book about Facebook, captured it well. He pointed out that one of the fundamental features of Facebook is that when you went on it and shared information or photos, you shared photos with your friends or the people in your network, but not with the world. In MySpace, the default was absolutely the opposite. So as he pointed out, when it came to Facebook's success, in fact, it was attributable in no small measure to the recognition that a degree of privacy protection was built in. If we look at where we are today, I think that privacy is alive and well, but perhaps the meaning of it has changed. Consumers do want to share more personal information. That is an absolute testament to Facebook's success. And that is at odds with the way many people for many years or even generations define privacy. In many ways, if people said they wanted to keep something private, often what they meant was they wanted to keep it secret. Privacy and secrecy were almost synonyms. That is clearly no longer the case. But there's a big, big but. People do want to share information, but they want to decide who they share information with. And they want to determine how this information will be used. That's the new definition of privacy, the ability for people to share and yet control how their information is used. And I thought it was so interesting that 2 years ago it was the youngest justice on the Supreme Court, Sonia Sotomayor, in the Jones case, who wrote a concurring opinion basically recognizing this very point. And the question that she posed was whether constitutional law would need to evolve, whether it would need to evolve so that secrecy was no longer a prerequisite for having a reasonable expectation of privacy so that something would be protected under the Fourth Amendment. She went far in suggesting that the time for change was approaching. I thought the biggest question that emerged was when would the Supreme Court as a whole embrace that point of view? Last month, we learned the answer. Because the Supreme Court issued its decision in Riley v. California, and in a year marked by so many 5-4 decisions, here was a unanimous Supreme Court, in effect, endorsing the proposition that Justice Sotomayor had offered just 2 years before. And Chief Justice Roberts, writing for this court, talked about cell phones as something that exposed to others the privacies of one's life. And a unanimous court therefore had no difficulty at all in concluding that the police could search the cell phone of someone that it had just arrested only pursuant to a warrant. This is a watershed development and a major change in the way we think about privacy as a matter of constitutional law. We were so struck by it that a week afterwards, we decided to conduct a public opinion poll of registered voters across the country the week after the 4th of July. What that showed was that 83% of American voters believe that the Supreme Court got it right, and the police should only access a cell phone pursuant to a warrant. 86% of the American public believes that the police should have access to data in the cloud only on the same terms as they do for information on paper. And interestingly, if you think about the law passed by the United Kingdom, if you think about the case before the federal court in New York, 56% of the American population worries that if the United States government seeks to obtain documents from other countries without going through legal process there, without recognizing due process and how it must be applied, then other countries will do the same. And guess what? Only 13% of Americans like the idea of foreign governments getting at American citizen data in American data centers without notifying the United States government or the individual involved. I think what it shows is a remarkable confluence between 9 justices who sit on the Supreme Court and the American people. And it shows that digital common sense is alive and well across the country. This also, I think, helps explain what we're seeing, the growing wave of legislation, starting in a place like California, where so many bills were introduced last year, coupled with the steps that we're seeing in so many other states. And of course, this is happening when we're seeing similar action literally around the world. Interestingly, if privacy doesn't matter to people, the people who are being elected by the people seem to be taking a contrary view. Ultimately, I think this makes eminent good sense, because we need to think about the future. We need to think about the Internet of Things that you heard a little bit about this morning. What does that mean? It basically means that over the next decade, every thermostat, every smoke detector, every fire extinguisher, every parking meter, every traffic light, every garbage can in this country and around the world ultimately will be connected to the Internet. And all of this data is going to be stored in data centers. And hence we need to figure out what principles and rules we want to apply to a world where information about everything is accessible potentially to anyone if they can get access to it, whether it's pursuant to legal process or in some other way instead. I think ultimately the questions that need to be considered when it comes to government surveillance and company use of data are in fact the same. The answers may differ, but I think the questions are the same, and there's fundamentally 4. First is, what level of transparency will exist so that people in an appropriate way know what information is being collected about them and how it is being used? Second, how do we ensure that people appropriately continue to have control over their information? Now, of course, individuals don't get to decide whether they're investigated by law enforcement, but they do nonetheless control that process through democratic processes and the transparent application of law. And when it comes to companies and consumer data, we will need a new consensus on how to make either notice and consent or something else work so that people fundamentally remain in control of their own most sensitive information. Third, there needs to be accountability. There needs to be accountability for government officials to the courts, and there needs to be accountability, in my view, for companies pursuant to reasonable, responsible, thoughtful regulation and the rule of law. And finally, we need to think about all of this in terms of how it translates across state lines and across national borders, because information is flowing around the world. In closing, I would leave you with this. We don't have a Bill of Rights in this country because the founders who met in Philadelphia in 1787 decided that it was necessary. We have a Bill of Rights because when their new Constitution went to the states, it was the state ratifying conventions that in place after place after place said that if we were going to have a government that it was going to have this new power, we needed to have a document that would forever protect the rights of people. And the fundamental voices that made that happen were not the people who went to Washington or its predecessor capitals. It was the people who got up every morning and went to work in state capitals. Across our country, it is the state attorneys general that solely among all of our public officials are elected in almost every state by the people to think about the needs of law enforcement and to balance those needs with the rights of consumers and people. And at various times in this nation's history, it is the states that have spoken out. And at various times over the last decade, on a variety of issues, it is the state attorneys general that have used their voice to make sure that the people across this country kept the proper balance in mind. As these issues unfold, there are people who will look to Washington. There are people who will look to the courthouse in New York, and yet I say it is also the people who are elected in each state who must have a fundamental role to play. Because it is only through this type of involvement by people across the country, people elected, people who help build this technology and elsewhere, that will ensure that as technology advances, our fundamental principles continue to endure. If there is one thing I've come to believe in 21 years of working at Microsoft, it is this. Technology is a tool. It is a tool that needs to serve people. But it takes thoughtful people who come together, who talk together, and yet who can also decide together. It is only through those kinds of people that we will ensure that technology serves the next generation of people. Thank you very much.
One word came to my mind, and that was wow. And then I had another one. Amen. Brad Smith for president. I think it's important to note, once again, referring to the New York Times article today, and Mr. Smith didn't talk about it, but I think it's important to reflect, and I think it would be obvious from his remarks already, that he's not just passionate about his company and trying to get a competitive edge against other companies who may be in the same space, which of course he is. But he's compassionate about the subject matter. He obviously is compassionate about history and the rule of law. And if you read the article, you will realize that by seeing that he has sought out his colleagues in the competitive industry that he's in to address this issue across the board. Certainly not to the benefit of his company, but to the benefit of the subject matter and to the benefit of all of us. And I think he deserves to be commended for that. So thank you, Brad. Now, he managed to shorten his presentation so we could get to lunch on time. However, I am guessing that his presentation has raised a few questions. Maybe my presentation raised a few questions. And either one of us is willing to field those at this time if you have any, first amongst AGs. Everybody's hungry.
Where's the food?
Yeah. Any questions amongst anyone?
if you do, and the British government seeks access to that data, what do you intend to do?
Well, I believe it's clear-cut in the United Kingdom and the United States and everywhere that whenever you have data in a particular jurisdiction, it's subject to the laws of that jurisdiction. We don't happen to have a data center in the UK. We do retain some data in the UK, and there is no doubt that any data that we have in the United Kingdom is subject to the law of the United Kingdom and a warrant issued by the British government. Where we draw the line is data that is held in the United States, for example, or data that is held in Ireland. We don't believe that that data is subject to a warrant issued by the British government, and we believe that the proper course for the British government in the short run certainly is to work with the government of Ireland or the government of the United States. There are treaties in place. Law enforcement can work together to provide data. We can be served with a local order. We can comply with it. And if those treaties are not good enough, there's plenty of room to focus on how to improve them. If they're too slow, we can find ways to speed them up. And I would also add that, if the British government had passed a law that applied only to the data of British citizens or residents, even when it resided outside the United Kingdom, that might have been a different legal equation. I think what is most disturbing is that this law applies to the data of all citizens and residents, even if they've never been to Britain.
Other questions? Hearing none, I think Karen, do you want to address everyone?